We're on the record on State versus Zimmerman, case number 12 CF 1083A. Attorneys, please make your appearances for the record.
Bernie Delario on behalf of the state of Florida.
John Doe on behalf of the state of Florida.
Mark O'Mara on behalf of Mr. Zimmerman.
Don West, here with Mr. Zimmerman to my left.
On behalf of Mr. Zimmerman.
Good afternoon, Your Honor. Scott Ponce on behalf of the media organizations listed in our papers.
And Greg Thomas on behalf of the Orlando Sentinel and the South Florida Sun Sentinel.
Okay, thank you very much. Before we get started today, I wanted to provide to counsel for the state and counsel for the defense the order disclosing the redacted medical records. This is the original. This one is for the state, and this one is for the defense. I have reviewed them. What I have done and provided to the state along with the order and the defense along with the order, instead of making a list of what is redacted and what isn't redacted, I've copied every record, and the portions that are redacted are not in there, but it will have the date of whatever the visit may have been. So those are in the envelopes that I are attached to the order, and the envelope, your envelopes are not sealed, but the original unredacted and the redacted ones are put in the court file under seal.
So I'm clear that you've now given the state a copy from which you've redacted certain items?
Yes, I've given, it's every page that has been provided to the court. Some of the pages just have the heading of the Altamont family practice with the date, or, you know, the
Right.
heading part, and whatever the court deemed not relevant or that should be redacted has been redacted.
Yes, Your Honor. Thank you.
We're here today. There are three motions that were set for hearing, and I don't know what order you want to go in. I was just going to go by the notice of hearing. The first one was the defendant's demands for specific discovery.
Yes, Your Honor. And as to that motion, we had filed a motion or a specific demand for discovery. As you recall, last time I had told you that it wasn't ripe. In the intervening time, I'd asked Mr. Delario on behalf of the state to respond to me. I haven't gotten a specific response from the state yet, but my request to the court is quite straightforward.
I've read your motion. I've read your memo of law. I've read the cases that you have provided. If you have additional argument, no?
I really think it's everything is in there, just simply that I think, to summarize real quickly, the state has an obligation to get us what we call Brady, or information suggesting that it's exculpatory. Under the case law that I've cited, that umbrella goes out to other law enforcement agencies, including federal law enforcement agencies. That would include the FBI, Department of Justice, and FDLE. I could present you evidence to support my position that I want everything from FDLE pursuant to your court order, because we know from the depositions we've taken we haven't gotten it all. So I just want something very specific so that I know FDLE is giving us everything attached to the Zimmerman case.
Okay, Mr. De La Ronda, if you would like to, Mr. Guy, are you going to respond?
Just briefly, Your Honor. Judge, if we can begin with the proposition that the defense is not entitled to every shred of evidence in possession of the state. What they've asked for in this specific demand is every conceivable shred or electronic piece of data to DOJ, the FBI, and FDLE. And to date, the state has supplied every report that it is aware of from FDLE, Department of Justice, and the Federal Bureau of Investigations. Additionally, we have provided the statement of every witness that has been taken by a member of those agencies. So I submit to date, the state has complied with its obligation under the Florida Rules of Discovery. And we understand it's a continuing obligation, and we will abide by that accordingly.
Okay. Rule 3.220 is the discovery rule here in the state of Florida, and counsel, I know, are all aware of the rule, as is the court. Subsection A binds the prosecutor and the defense to all the discovery procedures that are set forth therein. Subsection B sets forth the prosecutor's obligation to disclose material within their possession or the control. Case law includes any material, even if the party to any compact or agreement with the FBI or any federal agencies. And in support of that proposition, I would cite the State versus Coney at 294 Southern 2nd 82, Florida, Supreme Court 1973. Yanetta, Y-A-N-E-T-T-A versus State, found at 320 Southern 2nd 23, 3rd DCA 1975. And State versus Miranda, 777 Southern 2nd 1173, also 3rd DCA 2001. So it seems that the state's response is that they have provided everything there is and they understand that they're on a continuing obligation. So unless and until there's specific things that need to be addressed, I mean, just thinking there's something else out there, I'm not going to go look at the files.
I understand the court's ruling, so I shouldn't be arguing. But here's the, when the state...
Well, it's not necessarily a ruling. I mean, the state has responded, they've provided everything, so...
But we have evidence that that is not true in the past. So here's what I hear from what you're saying and from what the state is saying. If we can find out what it is that we don't have, then we can come to you and demand them to give it to us. I'll give you some examples of what they've given us that is inaccurate.
Well...
So I can't, here's my problem. What you're asking me to do is to take on the state's burden. When we look at Brady, we look at the case law cited, what it says is they have the affirmative obligation to go get it. So with the FBI is a perfect example. It's a law enforcement agency, it's covered by the case law, and what they're saying is the only thing that we have is 54 pages from the FBI, and we're giving you that. What I would ask that you do and what you demand under the case law is just say to them that they have contacted FBI.
I think that's what Mr. Guy just,
I'm sorry.
Please. I think Mr. Guy just said that he has given everything. You're asking me to almost, for me to prove a negative. I can't. You have means to take depositions or whatever means are available to see if there is any other information. All of you are officers of the court. And I have an officer of the court standing up at the podium on the record telling me that they have provided everything that they know is out there.
What he said was he provided everything they gave him. He did not say that they've had taken on the affirmative obligation of talking to the FBI and saying, what else do you have? And the case law specifically says they have that obligation.
They're in this case law, and I'm aware of their obligation. I'm assuming because he told me he knows he has an obligation for continuing discovery to supply any discovery that they're aware of. It's a continuing obligation that as an officer of the court, I am expecting him to abide by that.
Well, then...
So it's almost like you're putting the cart before the horse. You're saying that I suppose there's more information out there, and I have somebody telling me that there is not. So there's nowhere to go until that comes an issue.
So then I ask for this. If it now comes back on our shoulders to go find out what the FBI has in addition to the 54 pages that they've given to the state, and you're saying the state has no affirmative obligation to go to their other law enforcement officer and say...
I did not say any such thing.
But then let's have them say that they've done that, because I don't think that they've done, because I think they're sticking their head in the sand about additional information, because everything that seems to come out seems to be exculpatory, so they're not looking for it. So the FBI...
Well, you're making statements that I don't know are true. Mr. Guy, do you know if there's anything else out there? Have you asked them?
Mr. Delriano has spoken with those agencies, and again, to our knowledge, there are no reports yet furnished by the FBI or DOJ. And we have turned over the reports so far furnished by FDLE. And again, as the court mentioned, it is a continuing obligation, and we will continue to contact those agencies and see if any reports or any other interviews become available.
This court, what I'm trying to say, Mr. O'Mara, is that all the lawyers know what their discovery obligations are. If this court goes to trial and something else comes out, the state runs the risk of if there's a guilty verdict, they run the risk of that being set aside or reversed and a new trial ordered based upon some information that they failed or refused to give. They're aware of that. The case law that you provided is very clear on that issue. So, I have the representation from an officer of the court.
I also asked in my specific motion that we get native files and electronic discovery from FDLE. We have to avoid, and I would like to show this to the court if I might. And I'm going to make that a composite exhibit so that you get the feel for what it is that we get as information concerning my client.
Let me interrupt you for just 1 second. Sarah, if you will make this, any objections to this being introduced? No, Your Honor. This will come in as Defense Exhibit 1 to the defense demand for specific discovery.
And I would like to add this, since it's a composite, these are other ones to that
Any
composite.
objections? Yes, you may.
And then, Your Honor, this would be my second composite, which is the second round of information that we've gotten, which goes from...
Okay, just let me take this step by step. Any objections to these documents being added to Composite 1?
No.
All right, thank you. Any objections to the Defense Composite Exhibit that they're seeking to introduce as number 2?
No.
They will come in as Composite Exhibit number 2. Give them first, give them to Sarah. Okay, I'm sorry, go ahead.
Now, the first one is what they gave us under the guise that they're giving us all the discovery that they have. And they would come into you and say, well, we gave them everything. And that was the first composite. Then we said, what are these? They look like abstract paintings because, as you can see, you can't tell anything of what they are. So then we said, will you please give us the native files, give us the actual digital photographs, because we all know we deal in digital photographs. Then we got Composite 2, which are not digital photographs. They are now color copies of what they gave us in 1. Evidencing, of course, they had color copies to begin with, but they decided to give us, as the defense, the black and white.
Right there. Do you have the disc or whatever electronic means it was that you printed out those photos from?
Your Honor, may I respond to this since I'm the one that dealt with this? May I respond on
Yeah.
behalf of the state of Florida? I provided what they gave me first, which was black and white. Then they wanted color. But make sure the record is clear. All this evidence was provided to the defense. They physically went to the FDLE. I arranged a meeting. They went over there and met with the FDLE agents, and we arranged for all the evidence to be opened, and they had a camera. They took photographs of all this evidence, and then they said, we want colors. So then I went back and asked them, and I have provided not a color photograph, but the actual disc that FDLE gave us of those items, those photographs that the agent himself took, the analyst.
So you're saying you provided them with
That
this?
is correct.
Did you not get it?
Third time, my concern is not what they finally did on the third time on this particular one. My concern is that there is additional evidence that we've been trying to get from FDLE. Today, we were here
But you're standing here arguing about something now that you've gotten.
I have to, sorry.
And if you have it, then that is no longer an issue. What you're now seeking is anything that you don't know of, they don't know of, that may be out there.
This is what I want. I want the entirety of the FDLE file. Agent Lee seems to be the chief agent in charge. I want FDLE through the state attorney's office.
FDLE?
We went to FDLE and took our own pictures, and at FDLE meeting, that's when we found out about Trayvon Martin's phone that we had never known about before.
I don't need to hear all that,
Yeah,
but did you go to FDLE?
Yes, I did.
Okay.
They did not give me digital files.
Did they open it all up for you?
No, just the evidence, not the files, just the evidence, just pieces of evidence that we looked at. They did not give a, I understand that I'm,
Go ahead.
let me take a second.
I want to get down
I
to
am-
what you do and do not, were not
Okay.
provided. so-
Here's my concern, and I have to give you some history because it evidences where I am. Short history. We go in there to talk to, take a deposition of the person.
I don't mean to keep interrupting you, and I really apologize for that, but I do want to take control over my hearings.
Yes,
And if you're saying that you hadn't gotten something and then you finally got it, I really don't need to know about that unless you're seeking some other remedy. But, so I just want to know what it is that you think you don't have that has not been provided to you, and now we're talking about FDLE.
Okay.
And you said that you went there, and while you were there, did they open up their files to you?
No.
Okay,
No, what we're talking about is a tangible evidence review. So the phone and the tangible evidence had nothing to do with their file. What we found out, the deposition is not going too far into it, is that we did not have everything that FDLE has. So all I'm trying to do now is a very simple process. If you were to enter an order that says FDLE is hereby ordered to ship over to O'Mara all of their digital files, everything they have. Now, some of that will be duplicated because they have given us some, but under that order, I will now know that I have everything FDLE has in this case regarding my client. And that's what I deserve.
Well, let's talk about that, because 3.220 says that the state is supposed to provide you the right to, well, list what they know is available, or the means to copy, inspect. It doesn't mean that they have to copy, inspect. They have to provide the defense the opportunity to go there and look at everything that they want that's in that file and ask for what they want a copy of. Because there may be thousands of things in a room, and if you only want a copy of one, why should they copy thousands of things? So you're allowed to go back to FDLE, and if you want that in a court order, that's fine. You can go back to FDLE and inspect their entire file on this matter and ask them to provide you with copies of whatever you are seeking to have copies of.
Agreed. And what I'm asking for is electronic copies, which is not thousands of...
Whatever's in their file.
Right, so I want the order to say, if it might, that I want to receive all of the FDLE discovery in what we call native file, which is digital, so that it's not thousands of pages. I will get all of their reports the way they generate them, because they generate them not on typewriters anymore.
I understand
So that's what I
that.
want.
Well, if you will give me a proposed order, send a copy of it to Mr. De La Ronda. If there's no objection to the form of the order, I will sign it as is. If there is an objection, I'll recraft it.
Now, as to Department of Justice, we've received nothing. So is
Okay.
it the state's position
Well,
that they
we'll
have
ask them right
contacted
now.
DOJ and there is nothing?
Was it either you, Mr. De La Ronda, or Mr. Guy who talked to DOJ?
I will defer to Mr. De La Ronda as the person who's...
Your Honor, I guess it's obvious, the defense is aware. The FBI has been doing an investigation separate from this case, and that is their investigation. We can't get involved in that. In other words, that deals with security matters, not just regarding this specific case, but also other matters in terms of this community. And so I don't think this is our obligation to check with them when they're saying it's an ongoing investigation. Now, I've contacted the FBI. I've gotten all the FBI reports regarding witnesses' interviews, and I provided them. I am still constantly checking, so if there's something I've gone through, I'm trying to get them. But I provided those, including evidence that wasn't favorable to the state, where they interviewed an associate of the defendant who said he's not a racist, or et cetera. I provided all those under my obligation, and I contacted them. I will continue to contact them. But they, from what I understand, they have an ongoing. I don't want to know what kind of investigation they've done, because quite frankly, that's not regarding this specific case.
Well, who's making that determination?
The FBI, in terms of, they can subpoena, they can ask the FBI. They have the authority to go subpoena them. They can request that from the FBI, and then the FBI gets to respond to that. It's not my obligation to go and get that from the FBI. It's an ongoing investigation. In terms of whether civil rights or not, or whether there was a police department investigation, I think that's what Mr. O'Mara is trying to get at.
The case law says basically that the defense would have to exhaust all means available to get the additional information that they think exists and has not been produced. So that's what I meant by maybe we're taking the cart before the horse. Have you inquired by subpoena or otherwise of the FBI or Department of Justice right now?
The answer is no, and I believe the reason why is because I do think that the state, and I think the case law supports it, I think you reference it partially, but we can focus on some of the cases that say
I've read
that
every single one of the cases. I've highlighted them. I spent the entire night last night doing that. So
am I wrong?
I am aware of it. But even in the State versus Miranda case, in that case, the Third District Court of Appeals said where it was undisputed that the state made efforts to obtain, and this was not a case that you had provided, where it was undisputed that the state made efforts to obtain information not in its actual possession, which the trial court ordered produced. They went on to say the defendant made no attempt to subpoena the federal agencies. The court said, Third District Court of Appeals said it was confronted with the situation in which the state has made its best efforts to obtain the information and documents and did not allege there was any compact or agreement between the state and the federal agencies named in the trial court order, which would enhance the ability of the state to obtain the requested documents to no avail. The court, Third District Court of Appeal, quashed the trial court's order excluding a confidential informant as a state witness and also quashed the order granting the motion to compel. So that seems to be, the latest
leaving relevant evidence to repose in the hands of another agency, maybe it's the FBI, while utilizing his access to it and preparing the case for trial. What Martinez says, I think, is they do have an affirmative obligation to go get it. You know as well as I do that there's two people who can call up the FBI and get the information. Them and somebody else besides me. Because they won't give it to me, but they will give it to them if you tell them they have to go get it. Now, he sort of said two things. He stood up there and said, I don't know that it's my responsibility to go get it, but he said, if they give it to me, I'll forward it. All I'm saying is, look at Martinez and says, look, here's the reality. The FBI has been involved in this case for 4.5 months. I know that they talked to some 30 witnesses because they did give me 54 pages, but I don't have an agent report. I don't have a tasking sheet. I don't have anything that I know that the FBI has done only because of 30 years' experience.
Here's what I'm going to rule on that issue with the FBI. If you provide the state with a list of the things that you think the FBI has done, Mr. De La Ronda will then call the FBI and ask them, do you have this information? And if you do, provide it, and he will pass it on to you. That's the best
Thank
that
you,
I
Your
can do
Honor.
about
That is the perfect first
Okay.
step.
If you will put that in the proposed order, and that would also go for the DOJ.
Yes, Your Honor.
Okay, so have we completed that issue?
Did we make a decision on, I'm sorry,
No, go ahead.
FDLE? And I'm going to give you an order that
FDLE
says.
is in the states, the state really can produce anything FDLE has, but I said you're free to go to FDLE again.
Right.
And review anything that they have in their files and ask them to produce whatever it is in there that you want.
And I asked you to expand that to include all digital and native files, and like an order saying that they
Anything in
should
their
do that.
entire file. Now, we all know they're not required to create something for you.
Just what they already have.
But if they have something in their file, whether it be a disk, if they have a report, if they have anything in writings or electronic, and you're able to view it and you want a copy of it, they have to provide you at the same means they have it.
Perfect, thank you very much.
You're welcome. Okay, that takes care of that one. The next one that you had mentioned, second order, was the defense motion for protective order regarding sequestration. Mr. Flood is not available to appear, but he asked that I call him on the phone. So let me go ahead and do that right now.
Joe Flood, not so new, but still bad to the bone iPhone. Leave a message on.
Probably didn't want that played in open court. Let's take on the next one then and come back to
yes,
that
Your
one.
Honor.
You may hang up or press 1 for more.
Okay. The next one regards, there are two of them that are kind of intertwined, and we have the defense demand for specific discovery regarding the state's motion for gag order. Has that been provided so we can argue this?
Well, yesterday at 5 or thereafter, whenever they sent. The last couple hours of yesterday, I got their response, which seemed to have in it a dozen or so examples of media presence by me, so I consider that to be an answer to my request.
Okay. We also have representatives from the media who have moved to intervene in the state's second request for a gag order. I will grant their motions to intervene, so they may argue along with everybody else. Mr. De La Ronda, you go first.
Court. Mr. Romero, I think this is yours, isn't it?
Oh, sorry.
That's all right. Freedom of the press. We firmly believe in it too, Your Honor. It's ironic that one of the first things I do every morning when I wake up is walk outside and go to my driveway to get a newspaper, which I read every morning, because I still am old-fashioned. I like the actually printed version. I don't like just the digital. And I say that because in filing this motion, somehow the defense is implying that, we don't believe in freedom of the press, or that we don't believe in the right of the media to partake and to sit through a trial or sit through any proceeding and make comment on it. And I guess the gist of my motion, Your Honor, is not directed to the media, but to a defense counsel. And as I articulated in the motion for the gag order and in the supplemental memorandum, and I think the court has had an opportunity, hopefully, to review that.
I have read your motion, I've read your memo, I've read the defense's response, their memo, I've read the responses from the media, everything that has been provided as of, the latest was maybe 9 o'clock this morning, I have read.
Okay. I just wanted to highlight a few things if I could, and I don't want to belabor the point because the court has the motions and memorandum before the court. But I wanted to highlight a few things because I guess there's a difference of opinion between the state and defense as to what is meant by commenting about the evidence. As I take the defense argument is that they're allowed to comment about the evidence. Our position, and maybe it's the wrong one, is that neither party should be commenting about the evidence in terms of impacting future jurors. Because if not, what's the point? Why do we go to the trouble of picking a jury and hoping that they are not bombarded with media, which they are, and which the media has the right to do, in terms of report what's going on, but not to be influenced by biased comments by attorneys, because if not, what's the point? Then we would just argue in a public square as opposed to the courtroom. Why do we have a rule of law? Why do we have a courtroom? Other than to guarantee that the truth comes out in an adversarial proceeding where both sides have an opportunity to examine witnesses and make arguments in relation to what is produced, as opposed to going to the media and trying to, in some way, bias or prejudice potential jurors. And that's my concern here. Are we going to be able to pick a jury in Seminole County or anywhere in the state of Florida? And that's my concern. Now, I filed a motion for a gag order, quite frankly, almost within days of us being appointed in the case, because I saw where this was going. I've had these type of cases before, and quite frankly, a lot of times the defense files these motions. And so what we're left with is, we were appointed on March 22nd, that is the state attorney's office in the 4th Judicial Circuit. And the defendant was charged officially on April the 11th of this year. We filed a motion, our first motion was on April the 26th, so that is 15 days after we were appointed in this case. When we saw what was going on, I made a decision to file a gag order, motion for gag order. That was heard in front of Judge Lester, and he denied it. He said, as quite frankly a lot of judges do, both sides are aware of what's going on in terms of what the law is. Both sides are aware of the ethical responsibilities in terms of Florida Bar Rule 4.3.6 regarding trial publicity. And I guess that's where we're at, because from the state's perspective, since that first gag order motion was filed, the state feels that there is still a continuing process, both by the GC Legal, Twitter, Facebook, and other means, and then also by actually publicly speaking to the media, nationally, locally, in terms of commenting about facts of the case and evidence, commenting about the credibility of witnesses. I mean, why do we even have an ethical rule regarding that? If we're all just going to be allowed to comment about that, then we'll have a press conference, the state will have a press conference every day and say, we don't believe this witness, we believe this witness. This witness is a liar, this witness is not. What's the point? What's the point of having a trial? And so from the state's perspective, we feel that there needs to be some way, the court should fashion some kind of order to deal with this problem. This is a unique circumstance, and I commend Mr. Romero and the defense team in the sense that this is groundbreaking in terms of GZ Legal and Twitter and Facebook. I know they had Facebook only for a small period of time, and then they took it down. And so, and I commend them in the sense that they're trying something new. I don't know that it's been done anywhere else. I imagine it has, but that's creative on the part of defense. And they are trying to put their pleadings. Now, GC Legal goes beyond that, and it starts giving opinions about what was said in the courtroom. And they also start commenting about witnesses. And I just want to cite some examples. I did in the motion, but let me backtrack if I could and just slow down and cover. I wanted to break this, I guess, my motion in different parts. One is defense counsel created a website, GC Legal, dedicated to this case. They created a Facebook website dedicated to this case, and they created a Twitter dedicated to this case. And I believe they've even got one more. Now, I'm just talking about defense counsel. I'm not talking about the defendant. I am not asking the court to prevent the defendant from speaking, because quite frankly, as I mentioned in my motion, the times he has spoken in public, when he was interviewed by Sean Hannity, that was a godsend to the state. That was good for the state. So we don't have any objection. If he wants to keep talking to the media and he's interviewed, more power to him. I don't know that the court could honestly prohibit a defendant from speaking. But I think the court has the ability to muscle both sides, that is the state. I'm not asking that the defense only be, I am asking that both sides, and I'm even taking the position that you should muscle also in terms of prevent the police from talking about this. I'm not just asking in terms of favorable to the state, in terms of preventing the defense counsel from talking to the media. Well, what has happened as a result of this media in terms of the GC Legal? And I want to address these in parts if I could. One is the social media, I guess we call it. And I don't know if it's website or whatever we call it, but I hope the court understands what I'm talking about, because I'm new to this, quite frankly. I'm old, and you know, I still, now my kids are educating me as to all this stuff. But the state's position is that what is occurring here is really the attempt by the defense to bypass Orlando Sentinel, Miami Herald, all the local TV stations. Because in effect, that's what they're doing. You know, I think most reporters out there, and all I can say is the ones that I've experienced here, try to be objective. They try to present both sides of the story. They try to present both sides. Quite frankly, from the state, they usually get a no comment, or they can't even get us. But they attempt to be fair in terms of their interviews and reporting as to what occurs in the courtroom or outside the courtroom. This legal website goes beyond that, in that it is it gives biased opinions about certain things. So the defense counsel just doesn't post pleadings and court proceedings, but goes beyond that and engages and encourages discussions by John Q. Citizen. So what is going to happen in jury selection? We're going to probably have to spend, I would submit, maybe not, I hope not, 2-3 weeks asking all the jurors, what websites do you go to? Have you visited that website? What commentary have you made? Now, the defense gets all that commentary from people out there, and then they publish whatever they want, and whatever they don't want, they don't publish. Is the defense going to then be obligated to tell the state and the court if jurors appear, whether they've actually contacted them? That's an issue we haven't addressed. That's an issue that may arise as a result of this. But my point is, why was this website created? And I think it's important to distinguish between the websites and commentary by either defense counsel to the media in terms of giving an interview. So if I could, why was the website created? One could argue it was created to get funds for the defendant. That's, you know, they have the right to do that. I don't know if they do or not, but I'm not objecting to that. Was it done to influence public opinion? I would submit that's the real reason. Now, part of the defense argument, as I understand it, is that they had an obligation to do that because of what was done before, in terms of victims' families, attorneys, or whatever. And that they then have to respond because the defendant has been characterized in whatever fashion he has. He's been characterized as a racist, or he's been characterized whatever. But the end result of what they've achieved here by this legal medium is they're able to bypass the media. There is not a safeguard, if I could, I guess, describe it in that way. There is not a safeguard that ethically the media, the reporters, both in writing or by TV, the editors have an obligation to attempt to be unbiased and attempt to report both sides. There's not. There is The defense decides what they want to put out there or not. It's ironic that when the state filed their motion, the defense, what did they do in this case? They, I don't know if it's tweeted or whatever, they sent out through their legal medium a request, and then it went viral, I guess is the way they describe it, but it went all over, so then they had to put it on the website, a request for people to send examples of what, if anything, they had done outrageous so they would be prepared for this. If they hadn't done anything wrong, or if they didn't feel like anything was even close to the line, why was there a need to do that? Now, maybe it was because they wanted to see what out there was potentially so that they would be prepared. That's their right. But, and I know the court, I got this as part of the defense exhibits, I believe, in terms of the memorandums attachment. But I wanted to address and to provide to the court and to counsel, because obviously they've got it since they created it, is, thank you, is that first thing that I spoke of. That is their original, or what I perceived on October 23rd.
Excuse me for 1 second. This was part of your response to memo, so there's no objection to the.
Oh, absolutely no objection. I would
Okay,
like
thank
to review it.
Go ahead, I'm sorry.
And Your Honor, and that is part of the defense motion, but quite frankly, in fairness to the defense, that there's no dispute as to what. I have provided more in the sense there is, I don't know that his, and maybe it did, had the commentary by at least one person down there at the bottom. In terms of the one Twitter or responder or blogger or whatever word you use to describe this person, and I'm sorry, it's at the very bottom of the first page, Mr. O'Mara.
Oh, no, I know. Thank you.
And what that person thought is, well, maybe there was something objectionable. The only thing I can think of is there was some commentary by the legal website, and it reads as follows: for those who have given in the past, for those who have thought about giving, for those who feel Mr. Zimmerman was justified in his actions, for those who feel they would do the same if they were in Mr. Zimmerman's shoes. And it goes on to say, and this particular writer, I won't mention his name, but he's there mentioned, thought that maybe that's a point that could be taken out of context for those who feel they would do the same thing in his shoes. So what is occurring here is defense counsel, by way of this medium, is out there talking to the public, and one might argue, one might think, but based on what is said there, like, hey, put yourself in Mr. Zimmerman's shoes. Is that proper for potential jurors, for the public out there? And more importantly, if the court reads, and what I'm asking for in terms of the gag order, is that substantial likelihood of materially prejudicing an adjudicated proceeding due to its creation of an imminent or substantial detrimental effect on that proceeding? I would submit it has the potential for doing that. I mean, if anybody who reads that is saying, hey, basically put yourself in the defendant's shoes, is that proper? That's just one thing. Now, and I know that the quote was provided again by Mr. O'Mara with a bunch of stuff, but I cite one other one, or a few other ones. There was one that read, and I...
This marked as an exhibit.
Your Honor, the other one is titled, I apologize. I've got it. And Mr. O'Mara put part of this. I don't know if the whole thing was in there, but I just wanted to make clear.
Give them a minute to look at it.
I've seen it.
Any
I
objections?
think I wrote it, so no objection.
Okay. Are you seeking to introduce this?
Yes, Your Honor, if I could.
Come in as exhibit 2. You want to hand it back to me?
This one, I'll wait for it.
She just needs to mark it before.
Okay.
Thank you. Okay, go ahead.
Thank you, Your Honor. This one is titled, and I think it's dated October the 10th, 2012, and it's titled Race and the George Zimmerman Case. And it goes on to give commentary by somebody in defense counsel to talk about what's important and what not, and why they're reacting a certain way, and, whether race should be an issue or not. Is that the kind of discourse that should occur, that the public, that potential jurors are being exposed to by one of the attorneys involved in the case? And the reason I highlighted that, because the court, I believe, already had the first page, is I have the second page. And I think this is very telling from one of the bloggers or one of the responders to this. And I just wanted to highlight what this person said. And I want to highlight certain parts of those paragraphs. First, after reading the Crump interview in its entirety, parentheses, that is, as much as is posted on the site that you link, end of parentheses, I believe your article is misleading. From the second paragraph, at the very last sentence, thus, I would suggest that it is the vigilante nature of the incident that raised our fears and suspicions, and is the death of a teenager carrying Skittles that raised, parentheses, and sustains, ends of parentheses, our deepest sorrows. And then the next paragraph, third, the ones that I hear about talking about race at this point are the Zimmerman family and supporters, and now, unfortunately, Mr. Zimmerman's lawyers. So while your article purports to want to keep race out of the case, the fact that the defense side constantly raises it sends a contradictory message. And your accusation that Mr. Crump is projecting race into the case amounts to, well, projection. Next paragraph. We understand what your job as a legal defense team is, and we value your duty to provide a vigorous defense for the accused. But you degrade your important role when you stoop to targeting, and unfairly so, outsiders who are simply serving their important roles. And you might impair your ability to do your job well if you delude yourselves into believing that the story here is race rather than murder. And I guess this is not just when one person comments, this is the ability for John Q. Citizen out there, the public, to be reading this. And so what I'm trying to do by virtue of this argument and by virtue of these examples is highlight to the court the problem that we are, I would submit it, in the court, the public in general, and we as a society are now having to deal with. It's not that the reporters out there send something and publish something. It's now the attorneys are publishing and then commenting about what people say about the case. I think we're going down a slippery slope, because I think it's going to be problematic in terms of picking juries. Now, the media and their response, and I know Mr. Pence, and I apologize, Mr. Thomas, thank you. Ms. Fugate was here previously, will respond and say, that happens. That's part of freedom of the press, and that's true. But the question is, should an attorney involved in the case be involved in that versus the media, which they have a right to do, reporting on it? I mean, this, I would submit, is groundbreaking in the sense of we are at a new threshold in society in terms of the fact that now everything is Twittered, now everything is, it's like, why do we go to the trouble when the Supreme Court passed the latest instruction about computers and about not tweeting and not Facebooking and not all that? Why did the Supreme Court address that issue recently? I think it was within the last year, in terms of the specific instruction that the jurors now are told, I believe, at the beginning, during the trial, and after, and before they deliberate, about the fear of the influence of that. And I think we're headed that way. I think we've already gotten it there. And so I am, I guess, requesting the court to curtail that in some way, to not allow defense counsel to be commenting about the facts of the case. Now, defense counsel will say, and I think in their argument, very eloquently talk about, we're not really doing that. Let me address a few more points regarding this issue, regarding, first of all, the commentary through the legal website. I believe it's part of their exhibit, and I didn't bring extra copies because I know the court has it as part of their exhibits. It's under Exhibit 3 of their memorandum. It's titled Defense Closing, the George Zimmerman Legal Case page on Facebook. They talked about how Facebook helped achieve their goals, and their goals were, and I apologize, I'll let the court take a few minutes to.
I have it, I read
Okay.
it.
Number one was discrediting and eliminating fraudulent websites and social profiles, providing a forum with communication with a law firm, acknowledging the larger significance of the case. Now, providing a forum for communication with a firm. So, does that mean now that every case before this court or any court, that both sides will be able to go and say, hey, contact us, what do you want to know about the case? Let me tell you my side of it. I mean, why do we even pick a jury? Why do we have a trial? And more importantly, are we going to be able to pick a jury? And are we going to be able to have a trial where it's going to be a fair trial? And then they go on to say how Facebook hasn't helped. Because the problem, and that's what I would urge the court to emphasize there in terms of how it's not helped, because I think the defense realized that they weren't able to, and I apologize, I may be misstating, and I'll apologize to Mr. Romero profusely if I'm wrong, because he's obviously much more versed on this issue than I am in terms of the media. I think Facebook, there was something where they couldn't control, and I don't mean improperly in terms of control, but the ability of people to respond was kind of beyond their domain or their control. And so I think that's why they shut it down, but quite frankly, I may be wrong about that, and they're able to discuss it much more eloquently than I am. But the end result is they say that they decided to shut it down, and they did. But it was still there for a while. I think Facebook, they're not able to monitor as much, and people are able to respond to one another and communicate without going through the law firm. But so the state's concerned about that. Now, there's another part, and that's also in part of State's Exhibit 3, which is titled, ironically, The Responsible Use of Social Media in a Legal Defense. I don't know if the court has, I know that it's titled there, and I believe, I didn't copy it because it is provided. It's dated May 1st of 2012.
I only have 2 pages under Exhibit 3, and that's what you were
Oh,
just discussing.
I apologize, let me.
I don't have it. You want to show it to you?
Thick one, I apologize, it's defense exhibit.
Exhibit 2. One is the website, and 2 is the,
I apologize, it's under exhibit number 1. I apologize to the court.
what's the title of it?
It's titled The Responsible Use of Social Media in a Legal Defense. And it's about, I will tell you exactly what page, it's 1, 2. I think it's about 13 or 14 pages from the beginning, at least my stack, and I believe all the stacks are the same. It's the
Have it?
It's ironic that in this particular heading, one of the titles is, "We will not use our online presence as a vehicle for dissemination of, nor will we comment on any evidence regarding this case." Now, jumping forward, defense argument is, as I read it, that they're allowed to comment on about the case, that the rule does not prohibit them from commenting about the case. Well, when they created this website, why did they go to all the trouble of putting in there that they shouldn't be commenting about the case? They did not realize the impact that it would have on getting a fair trial, on both sides getting a fair trial. It's not just the defendant's right to get a fair trial, it's also the state's right to get a fair trial. And that is the state's concern here. And so it's ironic that they're in their own website, they talk about not commenting about the case. Maybe things have changed. Maybe now the defense feels that they can comment about the case. But one of the things that they highlight in terms of being responsible is not to comment about the case. So I just take that as another example in terms of the court's consideration in terms of what we're dealing with here. Now, at some point during this process, there were comments made by defendant's brother, Robert Zimmerman, Jr. And he made some comments out there. He went on a campaign and he did some Twitter comments. And the defense, as part of their legal site, and I believe that's also part of the state's package, but I've got the whole, I'm going to give it to, I'm given to the court now as an exhibit, and I'd like to put it in evidence.
Mr. O'Meara?
No, again, Your Honor, I think I
It'll
created
come
this.
into evidence as State's Exhibit 3 to this motion.
This is dated October 11, 2012, regarding Robert Zimmerman Jr.'s media campaign and Twitter comments. And basically that they state there they're distancing themselves from any of the defendant's brother's comments out there that don't associate the defendant or the law firm with Mr. Zimmerman's brother's comments, that they're not, they're different, and they're not vouching for what he says or doesn't say. The reason I provided this to the court is on page 2 of that page. It's interesting that the defense counsel, or somebody for the firm, in terms of addressing, I guess, somebody's comment on the middle there, state, we published your comment because it was a thoughtful look at how people are responding to this case online. We agree with you that there is too much emphasis on taking sides and that there is too much speculation on the discovery that is public information. And now, this is what I want to emphasize to the court. The only proper place for a discussion about the details of what happened the night of February 26th is in court. Well, why can't we all agree that that should be the place to discuss the case and not in the public arena? And that's what the state is asking for. I'm asking for what the defense counsel is telling people that's what should occur. So why is there an objection to a gag order to prevent attorneys from talking about the facts of the case or commenting about the credibility of witnesses, except in a courtroom, in a proceeding where both sides are present and the court is able to monitor and deal with it, and where the media can be present?